Hi, this is Dan Smith of DPS Legal Counsel. Welcome to today's podcast episode of Legal Scrubs. Today I want to talk about an issue that comes up quite often when physicians get to the point where they're ready to maybe retire and sell their practice, and they've lined up a prospective purchaser of their practice, and everything looks to be really great. Everything's going forward. And then a question arises, hey, what do we do to comply with all the laws applicable to the transfer of medical records? So today I want to talk about two big things that doctors need to be aware of when selling their practice with respect to the transfer of the custody of their medical records to a purchaser of their practice. Now, the first thing to be aware of is a federal law that doctors are well aware of from years of practice, and it shouldn't come as any surprise that when they transfer their records, this thing pops up again, and you have to take it into account. And this thing I'm talking about is HIPAA. Doctors are familiar and well experienced with dealing with HIPAA in their medical practice, making sure they keep patient information, patient health information secure and private. And when it comes to the time to sell their practice, they need to keep that same attitude. They have to make sure they take into account that their patients are still their patients, and the medical records of their patients are still private, and they should be kept secret, kept confidential, and kept from being disclosed inappropriately in the context of a business arrangement. So what does a doctor do? Because the buyer, let's say the buyer is another doctor that is in your town and wishes to buy your practice, but this doctor, his patients are not your patients, and your patients are not his patients, but he's interested in having the chance, at least, to acquire your patient load. He thinks that if he buys your practice and things go well, that most, if not all, of your patients will become his patients, and his practice will expand. But you can't just turn your patient records over to someone, even another doctor, without safeguarding the confidentiality of your patient records. Say, for example, this doctor that you're going to sell your practice to, say that these patients don't become his patients. Say they get notified that you're going out of practice or you're leaving practice and selling your practice, and they decide to go to another doctor in your town, not the doctor who's buying your practice. The doctor who's buying your practice doesn't really have a good reason to be looking at your patient records or having access to those confidential records if he's not the physician for your patients. So what do you do? And also, let's throw on top of that, you've got a lawyer, the buyer's got a lawyer. These lawyers, they may be looking at and having access to business records as part of this transaction. What do you do about sharing that information with them? Well, here's what you need to do. You need to make sure that in the context of your business arrangement, your prospective sale of your practice, that you don't forget to be compliant with HIPAA. And if you disclose or transfer your records or make them available for review by another party that's not you, the treating physician of your patient, you need to make sure that that person has a business associate agreement that's compliant with HIPAA in place. So let's say that the buyer wants to get a list of all your patients, because part of the value of your practice is seeing what is your patient load. So it's understandable that the buyer is going to want to know if you have 10 patients or you have 1,000 patients. And so he says, I would like to see a list of your patients. And do you just provide that to him? Well, you really should not, because HIPAA applies even though you're selling your practice or planning to sell your practice. And so you need to get a business associate agreement with your prospective purchaser in order to provide access and disclosure to him of your patient, of the names of your patients and the list of your patients. Well, what about the lawyer for the buyer? The buyer's lawyer may want to look over these. As part of due diligence for the transaction, may want to see what his client is seeing. So the lawyer for the buyer also needs to be required in some manner to become a business associate for the purpose, at least, of reviewing the records. Now, I would say that many lawyers probably don't want to get custody of your records in any way, shape, or form because that puts too much responsibility on the lawyer. But the lawyer probably, it's probably not out of the realm of probability that the lawyers for both parties are going to be seeing some information that is confidential and protected by HIPAA. So the lawyers really should have to enter into business associate agreements as well as part of the transaction in order to represent their clients properly. So let's say that you now have proper business associate agreements in place with your buyer and with the lawyers involved, and you can make disclosure of certain information to the buyer because these business associate agreements are in place. That's great. So this goes along. So we talked about one thing now, a federal thing, a federal rule, federal law that applies even in the context of a sale of your practice, which is HIPAA. Now, what is the other thing I want to talk about? Dealing with medical records. The other thing is a state law in Tennessee. It's actually in the regulations dealing with physicians, and it requires that if you transfer your medical records on a sale of your practice, that you're required to notify all of your patients that you are leaving practice and urge them to seek and to engage, to work with, to have their records transferred to another doctor. Well, typically, as part of the transaction with your buyer, part of the agreement, or one aspect of the agreement, is that when you send this letter out to your patients, you would be urging them, you would be letting them know that you're transferring your practice to this particular new doctor, and that this new doctor will have custody of all patient records as part of the transaction. And you could encourage and urge your patients to consider having that new doctor become the doctor for your patients. Now, they obviously don't have to do that. Patients have the right to choose their own doctor. But part of what you would be doing in compliance with Tennessee state law is notifying your patients that you're leaving practice, letting them know who will have their records, and urging them to seek a new doctor. And you would hopefully, you would be your hope as part of what letter you would be sending out as part of this transaction, that they would consider having your buyer be their new doctor. Now, which patients do you have to notify? Well, Tennessee, the regulations provide that in Tennessee, you have to notify every patient that you have seen or treated within the past 36 months or 3 years, except you don't have to notify a patient if you've only seen them once, no more than once, within the last 18 months. Now, so you get a list of all the patients that you need to notify. You send a notice to them as part of your sale transaction to the new doctor. And you also would want to have, as part of your agreement with the new doctor, a medical records custodianship agreement. Now, it could be a separate agreement from the purchase agreement, whether it's an asset purchase agreement or a stock purchase agreement, whatever. It could be part of that agreement, or it could be a separate agreement. But you do need to have some provision either in your sale agreement or in a separate agreement that provides that the new doctor will take on the responsibilities and obligations of being the custodian of these medical records. Because even if even if a patient decides not to go to this new doctor has to maintain your medical records for the required period of time. In Tennessee, medical records have to be maintained for at least 10 years. Now, there are some exceptions where they maintain longer than that with respect to minors, with respect to people who are under a disability, with respect to, and then there's some with respect to certain imaging records. So when you're doing this transaction, you will need to speak to your attorney who's handling your matter about what the various record retention requirements are, because you're going to want to make sure in your medical record custodianship agreement or provision in your purchase agreement to provide that the buyer of your practice will comply with all record retention requirements of the state of Tennessee, including maintaining the records for the required period of time. And so that is the second thing I wanted to talk about. So we have HIPAA, which is going to apply in any sale of medical practice with respect to the transfer of medical records. And we have the Tennessee regulations dealing with record retention and notice to patients of a sale of a practice. When you're working on a practice acquisition or transfer, there are lots of things to keep in mind. There are lots of balls to keep in the air and juggle. One may be non-competition provisions. Another would obviously be the purchase price of the practice. Of course, you'll have a fundamental question whether you're selling assets or you're selling stock or equity interest in a practice. But don't forget to keep in mind that with respect to the transfer of medical records, you have to make sure that you remain compliant with HIPAA. In fact, you have to remain compliant with HIPAA not only once the transaction has closed, but during the due diligence aspect or portion of the transaction, when records may be shared as part of a buyer's due diligence with respect to your practice. So you make sure you have the proper business associate agreements in place with the buyer, with the lawyers involved. And then the other thing is you need to make sure you do the proper notification to your patients and that you have a medical records custodianship agreement or provision in your purchase agreement to make sure that the buyer is going to maintain and keep the records in compliance with Tennessee law. Okay, I know that's a lot. I hope this helps. If you have any questions, please feel free to reach out to me at DPS Legal Counsel. And thanks again for listening to Legal Scrubs. We'll see you again soon.